running slightly late as trying to push people into breakout rooms. This is a great reminder prior to trial and prior to competitions that you need to ensure that you have the most up-to-date version of Zoom. You can find ways to do that on the internet. You guys are all young students. I'm sure you can find that online, but this is a great reminder that the process works as everybody is upgraded. I see, I'm going to hide this video. All right. So those of you who don't know me, my name is Taylor Rex Robertson. I am one of the vice chairs and the lead case writer for the fact patterns for the past 5 years, including this one. What we're going to talk about today are trial strategies, dissecting a case, and dissecting your opponent. Just as a reminder, please mute and turn off your video. All right, so the first thing for dissecting a case, when you get the fact pattern the first time, there's going to be 6 witness statements, a dozen or so exhibits, and there can be a mountain of evidence, including the stipulations, the instructions, etc. And so the question becomes, well, how do I sort that in the best way? Best way to do that is by actually sorting the evidence. And the first thing to remember is everything is in the fact pattern for a reason. As the lead case writer, I spend a lot of time over single words that are included or various exhibits. Everything is in there for a reason, but that doesn't mean that the reason isn't that it's just a plain red herring. It's something to take you off track. It is something to distract you from other themes, something that contradicts a theory that you might have. So just know that everything is in there for a reason. It just may not be for a useful reason. And as I'm sure all of you know, you have a very limited time at trial. This requires you to sort the evidence by strength. What are your best pieces of evidence? You don't have time, and it wouldn't be prudent to use all of the evidence. Judges want to see you making concise, cogent arguments. And so as you go through the evidence, you want to see, well, what's your biggest piece of evidence for the side that you're preparing for? What's the biggest strength? What is the biggest threat or weakness to that side? And again, what is the most efficient way to prove that theory for whatever side of the case? And then finally, what is the most compelling? What is going to ring in the judge's ears and in their heads once you've sat down at the end of closing argument? And again, there's so much, so how do you do it? Oh, I've come up with a alliterative theme of Taylor's tactic number 1. You're going to use what I call a case map. Again, these are just suggestions. You are free to use whatever system that you like, but at least me, even in my actual litigation practice, I use what's called a case map. So what is a case map? A case map is an outline. It basically separates all the elements you need to prove a cause of action or a defense. You then list all the evidence that will support or weaken that cause of action, and through this you will flag issues. This not only organizes all the evidence, it will help you generate theories and themes, which we'll talk about a little bit later, and helps you identify weaknesses you may not have seen or identify strengths that you may not have realized are there. So here is what it sort of looks like. So for our clinic fact pattern, what we had was the shouting the fire in the public place. And so you'll see here, the first step is to break down the elements. So here, the defendant intentionally caused danger to the public by causing persons to be in fear for their lives by igniting, shouting, being on fire, one of those 3 options in a public place. So for me, my short list is intent, an intentional act that causes danger to the public by causing fear of life, one of those 3 fire elements, igniting a fire, shouting fire, being on fire, public place. And so you'll see, you essentially just create a spreadsheet. It's the easiest way to do it. You'll see I have on the left-hand side all of those elements, and then I add a piece of evidence, a strength of that evidence, perhaps a weakness of that evidence, and an issue. So the first one, intentionality. There was an intentional act, and I've used the first and last initial of the witness in the statement. The witness that's PP, the magic trick by design involves setting the flag on fire. So it's not by accident. The defendant intentionally used fire as part of the magic trick, but there's a weakness that you may not see. Somebody doesn't actually see the fire, they just learn it through hearsay. Somebody else isn't really sure they even saw a fire. And if you move down to the third element in fire, or the fourth element on fire, was it actually fire or was it an illusion of fire? And if you do this grid that you see on the screen for all of the elements, and the clinic fact pattern is far shorter and has far less kind of substance to it than the case fact pattern this year or in previous years, this case map will end up looking really long. And that's not a bad thing. That will then help you sort through, well, hey, these 3 or 4 pieces of evidence are the most critical, have the least weakness, and therefore those rise to the top of the list when you're sorting through the evidence of what is going to make the most compelling and efficient case. The same works for defense. You're just now using weakness as the highlight. If the prosecution introduces this piece of evidence, this weakness is what we will exploit on defense. And I just put this together in about 10 minutes. It will take you a long time, but I think it's an excellent way to organize the case that you're going through it without being overwhelmed. Okay, themes and theories. I'm sure you have heard those 2 phrases, and I may be repeating myself, but we'll start with a theme. The theme of your case is that memorable soundbite, the most famous in all of litigation: if the glove don't quit, you must acquit. It's what echoes in the jury's mind after you've rested, and in real life, what they think about during deliberations. And I see students I've judged now for 6 or 7 years that I hear a theme in opening statement and I never hear it again. I don't hear it in close. I don't hear it from witnesses. That is not a good, effective use of a theme. Now, that's not to say to overuse it. I've seen teams as well that repeat the theme in opening. Every witness says the theme and then it gets said 10 more times in close. I think that's too much. But if you use a theme, you need to repeat it later, at least one more time. And so a tactic that I will reveal that I think is extremely useful is, can you get the other side's witnesses to say your theme? If so, I think that's very powerful. So how would you do that? Well, perhaps in a witness statement, there is a 2 or 3 word phrase that becomes your theme that witness is going to have to say in cross, or you're going to get to impeach him, or hopefully both, so that you can say it 2 more times. Think if you can do that. Now, another tactic is, once you settle on your theme, can it get flipped on you? Because if it can get flipped on you, it is not a good theme. And I've seen themes that start off really well and sharp, very strong opposing teams flip that theme right back on you. And a great way to do that is have everybody on your school, in your team, come up with a theme and then try and break each other's themes down. How can you flip that theme in a way that destroys your case, weakens or undermines your case? And after all of that, well, which one is the most resilient? Which theme holds water longer? Which one conveys everything that you're trying to say in a more persuasive and efficient or unique method? I've seen in past years 10 teams use the same theme. Now, of course, you don't know that before you go in because there's not scouting. You may have scrimmaged somebody. But if you have a unique theme, that's far less likely to get flipped on you because they haven't thought of it. And it will make your team stand out more. All right, contrast that with case theory. Theory is the legal way you will prove your case. Essentially it's clue. Your case theory is Colonel Mustard killed Miss Scarlett in the ballroom with the knife at XYZ. So the theme is more your soundbite. The theory is how you're going to prove it. And a famous mock trial advocacy program or kind of a student tutoring program talks about theory with the 3 U's, if you haven't heard it. The theory must be understandable, something that a jury can grasp as non-lawyers. Even though in your purposes they are lawyers, they still are acting as jurors. The theory must be unimpeachable. It must be solid, no holes, and everything is chained and linked together. And finally, it has to be unforgettable, just like your theme, something that resonates once you've closed your case and once the case has been sent to the jury. And so another tactic, there will not be just one theory. In fact, there are some fact patterns where there are a lot of theories, much like Clue. There's a whole bunch of ways you can estimate how somebody, at least in Clue or perhaps this year, got killed. Think about those theories. Those will develop from your case map, and do not get stuck on one early on. In my own mock trial practice in law school, change themes and theories the night before a competition because something just all of a sudden revealed itself, and you have to be flexible and able to move. Something may get exposed to you in a preliminary round that you realize, well, okay, now our theme does not work anymore. So you must be flexible. And again, I think the case map works as a solid foundation for revealing themes to you and revealing case theories. Okay, moving on. Witness control. I'm sure if you are in this advanced and intermediate class, you understand this, but from the perception of a presiding judge and a scoring judge, witness control is critical to separating the best teams from strong, but not the best teams. And you must prepare for every type of witness that you're going to get. In practice, your witnesses should not only play themselves, how they're going to act as witnesses in competition, but take on different characters. Be the most disagreeable, hard-headed witness one day. And then the next day, be the most lovable, I'll agree with anything you want. This is great practice for the lawyer on how to handle the witness. Because for me, in my practice, the first 10 questions, I'm usually just feeling the witness out. Are they being very disagreeable? Are they giving me long-winded answers? Are they giving me short answers? Do they sound like they're angry or upset or tired? It's kind of this feeling out approach. You on cross will get a little bit of that on direct, but I'm sure you've seen many times where the witness on direct is a different person than when they get on cross. And sometimes that happens. So preparing for the types of witnesses will help you approach them. And so I think the number one issue with witness control, right, is the witness not answering your question as asked. One second. I think everybody knows the process of objecting for non-responsiveness, asking the judge to instruct the witness not to answer. My tactic that I wish I could convey to every team before every trial is do what I call climbing the ladder. The first time that witness does not give you the answer or is partially non-responsive, do not run to the judge. It makes you look weak and it makes you look like the witness is controlling you. So the first time you don't get the answer, ask to, tell the witness, I'm sorry, maybe I wasn't clear. Let me try and rephrase my question. Then if you still don't get the answer, Mr. Smith or Mrs. So-and-so, please listen to my question and answer that question. Ask it again. You still don't get it. Then, Your Honor, I'm going to object to the answer as non-responsive. Can you please instruct? Now you have built your way up so that you're not running to essentially mommy or daddy, the judge, the first time you don't get your answer. And you need to be careful with your questions. I have had plenty of objection non-responsive when the question itself was open-ended and the witness pretty much answered it. Use that only when you absolutely need it. Because if your question is not tight and is not one fact questions like you should on cross, the witness is going to have room to wiggle. And I or another judge are unlikely to sustain that objection if your question didn't call for that narrow answer. And finally, stay in control. The number one rule is your emotional level should never surpass the witness. Yes, there are times in my practice that I have to get firm. I have to get almost forceful with a witness, but it's always because that witness has gone there way before I have. Don't ever let the witness pull you into an emotional state more than them, even if they're being frustrating, because that alone shows that you have lost witness control. And as actual lawyers who are judging your competition, one of the biggest issues in litigation is, of course, witness control on cross. And I think this is the best opportunity to pick up points and to show that you are one of these top best teams in your region, in the state, is through effective witness control. All right, I made this relatively short because I knew that I was going to have some administrative duties at the beginning, and also because I knew that there's going to be a lot of questions. I have plenty more to talk about if there's not questions, so I can answer those. Let me stop sharing my screen so that I can see the chat. All right, here we go. So you may type in the chat an actual question, or you can just say that you have a question. I'll recognize you and you can turn your microphone on and your video on if you want and ask that question. So the first one I've got from Diego. Do you recommend not cutting off the witness if they go off and waste your time with a narrative answer? So what I would say to that is, one, your question needs to be very tight. If you ask a question that's fairly loose and the witness is kind of starting to give some of the explanation, I'm probably going to let the witness go on. But if you feel the witness has gone on and is not answering your question, you got to give them a little bit of time to answer. You can't, the moment you think that they're going to try and start adding stuff that you don't like, you can't object at that spot. I alone, and maybe students are in here, I have had the objection non-responsive objection when the witness has only answered 4 words. I don't know if it's non-responsive. I actually have to listen to the answer before I can determine whether it's responsive or not. So I think you can cut the witness off if they start rambling. You can try it, right? Hang on, Mr. So-and-so or Miss So-and-so, let me redirect you back to my question. Or you can ask the judge, right? But again, you need to let the witness answer for a little bit so I can determine it is non-responsive. And again, climbing the ladder, if the witness does it 4, 5, 6, 7 times, you can then start shortening the time before you say, you're not answering my question, or asking the judge for help. The most effective I've seen when witnesses get off the rails and aren't answering the question is that slow climb up the ladder, such that by the 9th or 10th time, now the witness is only 5 words into its answer, and the lawyer's, Your Honor, I'm going to object, not responsive. The judge is frustrated at that point, and you have a lot more credibility. So it kind of goes back to the whole climbing the ladder of cutting a witness off, because you all know what happens, right? You cut the witness off in cross, the other side stands up, Your Honor, he's not letting him finish the answer, and you get into that whole back and forth. So give yourself credibility. You gave the witness an opportunity to answer the question, but they're still not answering it. Please instruct the witness to answer the question and climb from there. Okay, let's see. Paul, feel free to unmute and throw your video on if you have a question.
Okay, so my question is, when you're asking a witness, you're reminding them that they need to answer your questions and stuff like that. Is there any strategy you would give me to make sure that I don't get objected to harassing the witness or something like that? It's just something that's happened to me previously, and
I think if you do it in a solid tone, kind of back to the emotional, keeping the emotions even. I've seen the harassment objection when it's, Mr. So-and-so, I've asked you 20 times now, please answer my dang question. That, of course, is not going to work. But if I think if you do it nicely, like climbing the ladder, right? I used to do, I blame myself first, then I blame nothing, and then I blame the witness. Perhaps my question wasn't clear. Let me try and rephrase it, asking it. Perhaps we're missing something here, so we're try and rephrase it again. Now on the 3rd time, Mr. or Mrs. So-and-so, you're not listening to my question. Please listen to this question and answer this question only. I think then, even if you get the harassment objection, it's going to get overruled because now you've displayed 3 times you've tried to ask that question and the witness is still failing to answer it. So it's really all about building credibility with the judge. Judge, I have tried to give this witness every opportunity to answer it. Now I need you to jump in and help me. But I try to do a bunch of work beforehand.
Thank you.
You're very welcome. Anybody else have a question? Not, of course, about the current fact pattern. It doesn't have to be about trial prep. But I figured with 80 people in the room, I might get a bunch of questions, but we may not. Okay, I get to improv now. Let's see, what else can I talk about trial prep? So a couple things I had in the slides that I cut out. Okay, there we go. Philip, what is the best way to determine the elements? The elements of the cause of action will be in the stipulations. It may not be obvious, but you'll be able to pull them out. So for example, in your clinic fact pattern, one of the stipulations, the prosecution must prove the following elements beyond a reasonable doubt. And then it lists all these. You'll see I've highlighted and kind of broken down each element. You may break them down slightly different than somebody else. Yours might be intentionally cause danger as opposed to intent and then cause danger. It's kind of a personal process of how you want to break each one of those elements down. But that's where you'll find it. You'll also find it often in the jury instructions, but they're typically buried in the stipulations, such that, it will say to prove negligence. It requires a duty, a breach of the duty, causation, and then resulting damages. But yeah, without trying to get too specific, and I certainly don't want to stray into the current fact pattern, you will be able to extract it from the stipulations. And if not, or if there's only two, for example, or whatever, then you can start doing almost sub-elements of witness theories. One witness says this is how the case unfolded, or this is what they have. And you can start breaking those down one by one, and then finding the evidence that supports that and finding the weaknesses that may undermine that credibility. They said that the light was red, but then you find out that, they had just recently had eye surgery, or their vision was blocked by a certain area. And the strengths might be, he turned around and told somebody else 2 seconds later, hey, yeah, the light was red. That you can use it in that aspect as well. Let's see. Do you have any tips with increasing teamwork at the attorney table? Great question. So I get there's two schools of thought on that. And I don't fall necessarily into one camp or the other. There are judges that think that excessive communication amongst the attorneys with notes, first of all, you should always do it by note. Don't ever talk to each other, because it is distracting, and that's a great way to get the judge irritated. But, the sticky notes and notes like that, there are judges that think excessive note writing back and forth tends to show disorganized or a lack of kind of confidence. You can imagine that the three lawyers that just sit there, ask their questions, and don't ever communicate, that can display a very powerful sense of confidence. But stuff comes up all the time, right? It's a theory or an angle you've never heard a witness take before, or they say something, you're like, I'm pretty sure they said the opposite in their fact pattern. So then or their statement, you got to get it out and look through it. So I think notes is the best way to communicate back and forth. But you don't want to overdo it, because I think it shows a lack of confidence. If you're unsure in an objection, or you're unsure at the end of your cross, whether there's something else you want from your co-counsel, I think it's perfectly fine to say, Your Honor, can I have a moment with co-counsel? I think that's fine. I mean, if you do it once or twice during the case, I think that's fine. I do that in real life all the time, just in case you don't miss something. So I think that's the best way to increasing teamwork. But it's hard because you are kind of siloed. I mean, you have one student that does open, one that does close, and then you all have your own direct and cross. During cross, I've seen good teams that may do this. You don't have to, where you've got the one other lawyer that has all the exhibits ready to go and knows the order that they're going in and is ready to hand the exhibit. That's obviously not going to work this year given the virtual platform, and we'll get into the technological side of it at a later date. But for this year, I think it is going to be tough. I think at the table, you'll probably have to mute, and then you could maybe confer or send pieces of paper back and forth. But that's going to be something that we're all just going to have to work through, I think, this year. Let's see, Cedric, as a witness, is it a good idea to read the entire fact pattern the whole way through once, including the other witness statements? Absolutely. You should read it 3 times all the way through. Everybody should read it through once before they really start forming things. I used to read the whole fact pattern once, making no notes, no highlights, nothing. Then I would start all the way over again, usually another day, and go through it again. Now I'm highlighting and I'm tabulating. But yes, another witness, you should absolutely read all of the other witness statements. You'll see in addendums, right? Sometimes they'll say, I've read so-and-so statement, and they said a bunch of stuff that isn't true. People will talk about other witnesses in the statements. You need to know what they're talking about you or about the witness that you're playing. You also, of course, need to read the witnesses that is on your same side. You need to know what things string together between the three of you. If you need to put together an argument on what happened or what this person was doing or how something got in this spot, it's rare that one witness will carry the whole load on some big fact. I mean, it's just how mock trial works. And in real life, you usually have to string it together through multiple witnesses. Let's see, next, for case dissection, is there any way that you know of or can recommend to flip information from being pro-defense to pro-prosecution? I mean, I think if you start with the elements of the cause of action, right, that's what the plaintiff/prosecution has to prove. So I think it's fairly intuitive to work that from the prosecution side. Here are the pieces of evidence that help support each one of these elements, and then here are things that might undermine each one. Defense, you just flip it. You put the elements back on the page. What are all of the pieces of evidence, testimony, et cetera, that undermine or disprove each element one by one. And I'm sure you students know that as defense, you just got to knock out one element, but the process is still there to understand and disprove one element. So you're really just taking strengths and weaknesses and just flipping them from one side to the other. Let's see, somebody else. We've been in trial where opposing team went straight to the judge for witness control. The judge responded positively and got on our witness just to answer the question, yes or no. Do you recommend changing the climb the ladder if the judge acts like that? Yeah, I mean, above all, you have to read your judge. And I get into that in my next section on evidence. The judge will control everything. If the judge is, and I think this is really important for witnesses. If you are answering a question and you're really not being non-responsive, you're just kind of trying to fluff an answer. So you're not really, on the scale, you're really kind of in the middle, right? This is just yes, this is for an hour-long answer. You're kind of in the middle. If the judge gets onto you on a quick one of those, you need to know that you need to straighten the answers for the rest of the deal. Don't give the other team the benefit of complaining about your answers through the rest of your testimony. Witnesses need to adjust. If the judge is getting on to you about answering the question, yes or no, you need to start answering the question, yes or no. Because I think from a scoring judge's perspective, if a witness has to be instructed 3, 4, 5, 6 times to answer the question, you are not scoring points. Like, you are detracting from your team at that point. You have to adjust based on what the judge is doing. And I think the opposite goes true. You climbed the ladder, you did everything you could to get this witness to answer the question, and you ran to the judge, and the judge says, no, ask a better question. Okay. Well, later, I probably am not going to the judge, because it's kind of like an objection. If you make an objection on something and they overrule it, don't make the exact same objection on the exact same kind of premise, because you're probably going to get overruled. Sometimes I know students want to display that they know it's potentially objectionable. You've got to adjust, and that's a real life attorney thing. You have to adjust in the moment, because every judge is different. I may sustain an objection that every other judge may overrule, or vice versa, or it's a 50-50 split. So you have to kind of make in-game adjustments given how the judge is responding. In light of your addressing communication between attorney and the table, are competition organizers expecting the whole team to be together in the same room? So, I mean, I don't want to get into the technical stuff because we're still fleshing some of that out. So with the proviso that what I'm saying to you is not the rules, because they have not been formalized, I expect that attorneys and witnesses will be in separate rooms. This is one for technology, for echo. I don't know how many long Zoom calls any of y'all have been on, but I've done arbitrations on it. You have to have people in separate rooms or the echo gets out of control. You will certainly need to practice your own technology beforehand, much like you would practice presenting yourself in courtroom. So I would expect, but I cannot tell you for certain, that witnesses and lawyers will be in separate rooms, largely for echo. And on, you'll be able to see each other on screen, of course. But we're working through that, because obviously that cuts down on the ability to communicate amongst each other. So I don't have a great answer on that one. Let's see, Diego, is there a way to establish someone as an expert witness if it is not specifically mentioned in their testimony? For example, if they're testifying based off their profession. I mean, there's no rule against you trying to tender somebody as an expert. And oftentimes, I don't think we ever qualify people as experts outright in any of the fact patterns, at least not in the past couple of years. I certainly have seen teams that try and tender somebody as an expert, and the judge will give the other side the opportunity to, object to that witness as an expert. I would, from a strategic standpoint, I would probably advise against trying to tender people as experts, which may seem counterintuitive, but oftentimes witnesses get tendered as experts in a very narrow fashion that then becomes not helpful to the side. And I don't think it's as effective as people think. I think tendering somebody as I can't use criminal, but tendering somebody as business contracts expert or something like that, it doesn't really carry a lot of value to me, at least as an expert or as a judge. But that's part of the strategy. To establish him as an expert, it goes back to experience, credibility. You can build all that up. and then attempt to tender them as an expert. But I mean, that really goes back to judge preference. Some judges may decline it outright. Some may let you argue about it. But, you know, as with any litigation strategy, expect that whatever you do, the other side will try and do. And if you try and do something and then object to the other side doing the same thing, that really looks bad. So if you try and move somebody as an expert, don't be surprised if the other side then moves somebody as an expert. And when you start objecting to them doing that, that may start to look bad when you just did the exact same thing on a different witness. So I call it the famous case of goose versus gander. You know, what is good for one side will be good for the other. And so it's all about tactics that you use that could get flipped on you by another good team, which is a great strategy. You see one side do something, can you do it now? And can you do it better? Can you flip it on them through tendering an expert, or, you know, some strange objection to a piece of evidence that got sustained, that the judge apparently, you know, sustained, even though you think they shouldn't. Okay, well, can you now use that later? Even though you might normally not do that because you don't believe that that was a proper objection. I mean, the possibilities are endless in that type of scenario. All right, so we've got 10 more minutes. If anybody has any further questions, I think I was thinking about slides that I had cut for additional trial strategies. You know, back to one of the questions, definitely having witnesses read the statements, including the other ones. I mean, as a witness, the best witnesses that I've seen, at least from a substantive standpoint, almost have their fact statement memorized. And that is not to say that you need to sit there and memorize your fact statement, but they have read it so many times that they know that fact statement left and right. Because I'm sure you've seen the scenario, or maybe it's even happened to you, where the witness is on the stand and a lawyer asks a question, and sometimes it's phrased in your fact statement you said, but whatever it is, you know, X, Y, and Z. And the witness they're not sure. They're like, I think I didn't say that, but now I'm not so sure. And they're almost too afraid to say yes or no. The best witnesses never do that. They know that fact statement by heart. And I've seen it before where the witness made an answer, and I mean, I write the fact pattern, so I usually have a good memory of the fact pattern, and they said they had not said something. And in my head, I'm thinking, I'm pretty sure that they did, but that witness is pretty competent. And then the lawyer tried to impeach, and it really wasn't exactly what the question was, so it was pretty much an improper impeachment. But it didn't say exactly what the attorney had asked the witness, and the witness knew the fact statement so well, it was, you know, yeah, you might be able to argue that I said that, but that's not actually what I said. And the same goes for lawyers, especially on cross. You should know that fact statement better than the witness, so that when you get an answer that you know conflicts with their fact statement, you are ready to go. You know that that's going to be an impeachable answer. And we're not in direct and cross, but a great thing to do on cross, every question that you ask that witness, you should tie back to a piece of evidence or a fact statement. Every single question that I will ask in cross, usually, if I have a deposition, an expert report, if I don't get the answer that I like, I know exactly where to go. It's almost like a separate column next to every question. Go to exhibit 12, page 3. Like, I know I have a thing that I can go to the moment that they try and say an answer that I don't like. So I think that just the reading and the understanding of the fact pattern is extremely important. And I think for exhibits, you know, come up with all the ways that you can get that piece of evidence admissible into evidence, if it's not already, right? And then come up with the 10 ways that you argue that it's not coming into evidence. There are plenty of examples in prior fact patterns where a piece of evidence could be argued to come in, it could be argued to come out, and I've seen it where it gets let in one case for one argument, and for the exact same argument, it doesn't come in the other case. And those are written intentionally sometimes to where there is kind of a toss-up. So, you know, these case maps, these grids, I just highly recommend you do that across the entire fact pattern process. The elements, the witnesses, the exhibits, how they come in, how you keep them out. If they argue, you know, this hearsay exception, here's how we defeat that. If they argue this hearsay exception, here's our response to that. the best teams seem to have anticipated every scenario. And that's what good lawyers do. Good lawyers act like everything is going exactly according to plan. The other side has presented no surprises. They knew exactly what was going to happen before everything started. That display of competence, one, is not natural. I mean, it comes from lots of hard work and lots of practice, but real lawyers, and just I think anybody in the room can pick up on it very quickly, that one side is just far more knowledgeable and far more confident and basically inside the fact pattern than another team. That doesn't necessarily mean you win, but presentation is a lot of litigation. I can give the same 15 cross questions to 10 different teams, and I'm sure you all know one team is probably going to be a lot better than the rest of them, even if they're asking the exact same questions. So there's a substance and there's a presentation side. All right, 5 more minutes if you've got a lingering question. I mean, I recognize some names in here, but I'm certainly not going to remember. Like, I guess it's being recorded, so if you feel bad about it, but there's no shame in if you think it's a dumb question. I'm here to help you in this kind of rare 5 minutes about a fact pattern, or about the competition, but not about the fact pattern that is for this year's competition. All right. I guess let me think about other things I cut from my slideshow. Oh, somebody there?
Yeah, I have a question. I just couldn't type fast enough.
Fire away.
So can attorneys use like witness appearance on the stand whenever they get there? Like, say you're wearing glasses or something, and they're like, well, are you sure that you have perfect vision? Like, are you sure you could really see that because you have glasses? That kind of thing?
Yeah. So, I mean, the answer to that is, I mean, we have a no costumes rule. So obviously if you wear glasses, if you're wearing glasses on the stand, they need to be your actual glasses. But I can't recall a scenario where a witness, had a vision problem. So I guess my short answer to that is no. I mean, obviously the witnesses can be played by either gender, and they can be played by any student, right? So of whatever height, I've seen that before, where a student said something, how would you have been able to see that? You're only 5 foot tall. That doesn't play. I think all the scoring judges know that the witnesses are written without anybody in mind. They can be played by any person. So I don't think that's the most effective way. You should have plenty of other cross or damaging stuff from the fact pattern to go what I probably would consider outside the fact pattern on what a witness is wearing or looking like. Let's see. Oh, there is one. What is the line for unfair extrapolation? I mean, that's going to be judge dependent. I mean, judge dependent or us on the committee. I mean, the rule about reasonable inferences. So, I mean, I think, and this will be frustrating, it comes down to the reasonableness of it. I mean, if I hear the question or I hear the answer in a objection meeting or about an unfair extrapolation, I need to be able to tie it back to the fact pattern or to the statements with very little effort. If I have to start making inferences about, because I essentially will try and reconstruct how you got to that, when the witness says something that's not in the fact pattern, right? I will try and go back to the fact pattern to figure out, well, how can that witness say that based on the words in their statement? And if it takes me any effort, essentially, to start stringing those together, I'm going to find that as an unfair extrapolation. I mean, great teams, in my experience, don't ever do that. You have plenty in the fact pattern to put together great prosecutions and great defenses that I don't think you need to extrapolate. I know why teams do it, right? You're trying to find an edge that is something surprising that the other team hasn't thought of because it's not in the fact pattern. But I would just say that one, you run a huge risk that it's going to be an unfair extrapolation. Two, even if the judge or somebody doesn't recognize it as unfair extrapolation, the judges will, and they will recognize that something weird is going on. And you don't want your team ever to get caught in a scenario where there is a rules violation allegation and then things are starting to get looked into. Because, I mean, as a committee and as judges, as things develop through the course of the trial, we note to the judges, we are seeing instances where, for example, a couple of years ago, students are marking on the exhibits. That is against the rules. Or students are arguing that, the widget was found in the barnyard, even though nobody says that. That is unfair. Like, we start to hear things and you do not want to be on somebody's radar for that reason. And I think you just run a massive risk, because if you get exposed for an unfair extrapolation, your credibility is extremely damaged. And I think you've got more than enough to work with. The fact pattern this year, I'm not going into specifics, you could have a trial for a week on that fact pattern. Okay, so there is so much information in there that you don't need to you don't need to extrapolate. You can be creative and surprising, especially this year, without extrapolating. So I would just caution you to not even try to extrapolate. Yes, I mean, it talks about your mother in there. You can say that your mother was a nice person, right? And that's, I think, the great example. My mother is a nice person, or she was a gardener, right? Somebody might say, even though that's not in the fact pattern. But if you start saying, well, my mother was a chemical engineer, and that's why I was taught at a young age how these, chemicals react to each other, okay, that's clearly beyond the line. Because if you extrapolate to gain an advantage, that is when you're going to get dinged. When it's innocuous or it doesn't seem to matter, that's usually going to get overlooked. But when you use it to gain an advantage is when you're going to get penalized, and when you're going to have issues to deal with. And in trial, during competition, that is the last thing you want. Because what if your whole case centers on that extrapolation that you've done, and now it's been taken away, or you've been cautioned, or you've learned we can't use it anymore? You're going to have to start all over, or you're going to have to make in-game adjustments. And you want to make in-game adjustments according to what the judge and the other side is doing, not because you screwed up your case theory. That is not the good team. Great teams never do that. I guess that's my shortest answer. Opposing team last year objected to argumentative in our closing. What is the best way to respond to objections in that nature? Well, first of all, it's closing argument. You're supposed to be argumentative in closing. I think every presiding judge should know that, but to be honest with you, if I got that objection, that's what I would say. Your Honor, this is closing argument. It's meant to be argumentative. And I think you're done. And do it respectfully. Don't be like, Your Honor, it's closing argument. Of course, I think that's when you lose a little bit of credibility, because I say this without knowing that a team that's making that objection perhaps isn't the most experienced, and so you don't want to kind of shame them in that. But I would just say it's closing argument. It's the purpose is to be argumentative. Exhibits are generally available in each witness statement. Are there occasions when using them with a witness on the stand gratuitous, therefore waste of time? Exhibits are generally available in each witness statement. When using them with the witness stand on the witness stand gratuitous, therefore waste of time. I'm going to guess what that question is asking. That it's, are there times when it is a waste of time to have a witness go through an exhibit? Sure, but some exhibits sometimes may only come through certain witnesses. So in that sense, you got to get them in through them. But if all three witnesses read the contract about the widget purchase, and you're only trying to establish one fact, you don't need three witnesses to say the same thing all three times. I think, yeah, that becomes a waste of time. But that's strategy. I mean, unless that's some critical piece of your case that you need to show that three people saw something, that's kind of hard to answer. Thank you. We were pretty thrown off by the objection. Yeah, I mean, there's going to be stuff that you don't expect. I mean, knowing the rules, like the actual competition rules outside of the competition, like fact pattern itself, that will help you a lot when you get some strategy, objection, or something weird that occurred, so that you can point. I mean, how many times I've had students say they can't do that, that's against the rules. What rule? Like, what rule prevents them from doing that? And then they just kind of look at me. Well, I know the rules pretty well, but for a regular judge, unless you can point me to a rule, then unless I think it's wrong just based on objectionable character or whatever, then it's just like cross. Like, you got to have that one thing that you can go to prove your case. All right, so it's about 11. I'm going to end this breakout room, and you're going to be pushed back into the main room, and then we're going to do the second set again. In the next set, I'm doing, I think it's evidence, but it's not the evidence of admitting exhibits. So I think it's breakout room 3, just in case you enjoyed this class. But obviously, it's all going to be recorded, hopefully. And yes, it is. And we will make all that available. So feel free to disperse amongst your teams. But thank you guys very much.